All right, let's get right into a case that really pulls back the curtain on the massive power of the child welfare system and what happens when a parent decides to fight back. We're going to walk through the story of a mother in North Carolina and see how her personal battle raises these huge questions about free speech, parental rights, and the actual process that's used to separate families.
So we have to start with this really fundamental idea in American law, because it's right at the heart of this story. The Supreme Court has been crystal clear for a long time. The government telling someone they can't speak before they've even said anything, that is one of the most extreme things it can possibly do. Just keep that idea in your head as we go through what happened here.
You see, this story doesn't just begin with the child being removed from a home. It begins with a parent being silenced. And that's key. This isn't just some custody dispute. It's about whether a citizen can even talk about their own life and their own experience with our justice system.
To really get what's at stake, you have to understand the extraordinary situation Kelly O'Neill is in. Her lawyers call the court orders draconian, and you can see why. I mean, just imagine being told you cannot contact your own child at all for who knows how long. And then on top of that, you are legally forbidden from talking about your own case, your story, to anyone. Not online, not to the press, nothing. So you have to be asking, how in the world did it get to this point? Well, to figure that out, we have to go all the way back to the very beginning, to the moment the Department of Social Services first got involved. Because the process they used to kick everything off is now at the very center of this legal fight.
Now, what's so critical here is the tool that DSS used to separate Mrs. O'Neill from her daughter, and it's a tool that completely bypasses a judge. This isn't some courtroom drama where a judge is weighing evidence. No, this happens right on your doorstep, probably during one of the most stressful, terrifying moments of your entire life.
And this right here is the document at the center of it all. It's called a Temporary Parental Safety Agreement. So in that moment of just intense pressure, a parent is handed this piece of paper and asked to sign away their right, even just temporarily, to have their child at home with them.
And a lot of legal experts look at this and say, hold on, that's not a real choice at all. Like this analysis says, it's coercive. The threat is pretty clear. Sign this, or we're taking you to court, right now. For any parent, that is an almost impossible decision to make under that kind of pressure, with no lawyer, and it completely sidesteps the checks and balances a judge is supposed to provide.
This chart just lays it out so clearly. The difference is stark. On the left, you have what the law actually says. DSS has to go to a judge, they have to present evidence, they have to get a custody order. It's a high bar, and it's there to protect families. But this safety agreement, well, it's a shortcut. It's called extra statutory, which basically means it exists outside the established law. It lets the state get what it wants without ever having to prove its case to a judge first.
So Miss O'Neill is now taking this fight to the North Carolina Court of Appeals. And this is where the story shifts, right? It goes from a personal crisis in a living room to a major legal battle over constitutional and parental rights.
Okay, so the first big thing she's challenging is that gag order, and legally that's a prior restraint. Remember that quote from the very beginning? This is exactly what the Supreme Court was talking about. It's the kind of government action that courts are automatically suspicious of. The government has a huge burden to prove it's absolutely necessary. So, her appeal could go one of three ways. The court could affirm, which means they agree with the lower court. Or they could vacate, which means they cancel the orders. That would be the huge win for her. Or, and this is pretty unlikely given what's at stake, they could just decline to review the case at all.
The second challenge, this one is aimed at the no-contact order. Her lawyers are arguing that this isn't just a temporary measure, it's what's called a de facto termination of her parental rights. A formal termination is like the death penalty of family law. It has a super high legal standard. The argument here is that the court got the exact same result, completely severing the mother-child bond, but without having to go through that very difficult, legally required process.
And what makes this order so extreme is just how absolute it is. It really does defy what any parent would do. If her daughter sends her a text or an email or calls her, she is legally forbidden from even responding. As another court once said, telling a parent they can't even answer their own child, well, it goes against the very instinct of being a parent.
And that brings us to another really critical layer in this case, how the child welfare system and disability rights intersect. This is a huge question, not just for Miss O'Neill, but for families all across the country.
So you have this fundamental question. Is having a disability a barrier to being a parent? Now, the law has already answered this, and the answer is a firm no. But the reality of what happens in these cases on the ground can be a very, very different story.
And look, federal civil rights laws like the ADA are incredibly clear about this. Public agencies like DSS and the courts have a legal duty to make sure parents with disabilities are treated fairly. That means they can't make decisions based on stereotypes, and they have to provide reasonable modifications. They have to adapt their services so a parent with a disability gets an equal chance to succeed.
And get this is a really critical point. If the state fails in that duty, if it doesn't provide the right services that account for a parent's disability, that can actually be a legal reason to keep a family together. The law is designed to say that before you take the drastic step of terminating rights, you have to prove you gave the parent the right kind of help.
Okay, so let's zoom out from this one case for a second and look at the broader system. And we can do that using North Carolina's own data. This helps us see if the problems in one family story might be part of a much bigger picture.
0%. Yeah, you're seeing that right. According to a 2024 state review, that's the percentage of cases in the entire state where mothers got caseworker visits more than once a week. For families who might need really intensive help, that highest level of support just wasn't happening.
And the state's own review shows these big gaps in more detail. I mean, something as basic as a caseworker visiting regularly is crucial for helping families. But as the data shows, weekly visits for mothers, it only happen in about 6% of cases.
That same report also found that while the state was pretty good at figuring out what kids needed, there was a real drop-off in actually providing those services. In 1 out of every 4 cases, kids were not getting the appropriate services they were supposed to.
So when you put it all together, it really suggests that this one incredibly personal story might be a symptom of much larger systemic problems. This data, showing gaps in services and support, gives you the context for how an individual family's case can go so wrong. And that leaves us with the central, really tough question, doesn't it? It's the tightrope the entire child welfare system has to walk. How do you balance the state's absolute duty to protect children with its constitutional duty to preserve the family? There's no simple answer, but asking the question is absolutely essential.